यस इट स्टार्टेड ना। अभी आप इसको जो इसका जो यूआरएल है कॉपी कर लो और इसको वहां से ये से जूम से पॉज कर दो। ऊपर जो यूआरएल है जिसमें सर्च पेज जहाँ पे उसको क्लिक करके एक बार एंड नाउ यू कैन पॉज और इसका जो यूआरएल है कॉपी कर लो और इसको वहां से ये से जूम से पॉज कर दो। ऊपर जो यूआरएल है जिसमें
सर
सर्च पेज जहाँ पे उसको क्लिक करके एक बार एंड नाउ यू कैन पॉज और इसका जो यूआरएल है कॉपी कर लो और इसको वहां से ये से जूम से पॉज कर दो। ऊपर जो यूआरएल है जिसमें
can you
सर्च पेज जहाँ पे उसको
just see in the chat.
ये सेम आवाज क्यों आ रहा है बार बार?
Sir, see in the chat the URL.
Yes.
Aarti, you are logged in on 2 devices?
No, sir, I have not yet logged in. I'm only on my laptop, but probably my YouTube was also on. That's why.
Because whenever you are speaking, there is a noise.
Yeah. Maybe because I was on YouTube as well as on Zoom. So
now it is clear. Now it is clear. Now it is not noisy.
Most likely the YouTube sound was coming.
Yeah, I have paused that, but
you can pause or stop live streaming now.
Dipanshu, log in from one a device if possible, huh?
Yeah.
Dr. Sandra has also joined. Should I share the links to in every A?
At least in YOSI, sir.
Yes, sir. Dr. Dipanshu, Dr. Sayantan, we all the best for the session. We can start in next 3 minutes time. I have started admitting the audience.
So the thing is, like, I'll give the brief introduction of our panelists and speakers, and then probably we can start with the talks of both the speakers. And at the end, like, we can have discussion with the panelists. Is that okay?
Yes.
Now is my screen visible?
Yes, it's visible. Just put it on the slideshow mode.
I have already put it. Let me know once it is on full screen mode.
I think this slideshow is not starting actually, or not working. So you can keep it like this only.
Or you can log out. Dipanshu, you can log out, open at the slideshow mode, and then share the screen. Since we have couple of minutes, you can try that if you want.
मैं ऐसे ठीक रखता हूँ, लॉग आउट करने जाऊंगा तो फिर व्हाट्सएप क्या दिक्कत है?
Save me data. We are logged in. Mute करनी है. You're not mute.
Dr. Dipanshu, I think we can start. It is 9.
Hello.
Yes, Dr. Dipanshu, you are audible.
The problem is there is a power cut at my place. I'll be right now operating from phone.
Okay, I think we can start. Welcome everyone to the this
Good
second
evening.
webinar on Consumer Protection Act by the YOSI Code legal team, and we have 2 speakers with us, Dr. Nimisha Nagpal, who is working at Shankara Nethralaya now, and the advocate Suman Banerjee, who is a lawyer, and we have Dr. Sayantan, who will introduce Mr. Suman, and then we.
Sir, I'll do that. No problem.
Yes, Dr. Dipanshu. If things are working, please.
Okay. So we have good evening to all, one and all. Today we have 3 panelists with us, very senior to all of us, and we are blessed to have them on our session as a panelist. First, we have Dr. Anand Deshpande sir. Next, we have Dr. Prakash Marathe sir, and third, we have Dr. Manoj Mathur sir. So, starting with Dr. Anand Deshpande sir, he has been awarded. He has been the director and eye surgeon of Guru Prasad Netra Rugnalaya, Aurangabad, and he has been director of Indian Medicolegal Consulting Services Private Limited. He is also the chairman of All India Ophthalmic Society and other state ophthalmic societies as well. We have, and he has been awarded with various awards like India Award 2012, Atwale Award, and Lifetime Achievement Award by Ecoin. We welcome you, sir. Next, we have Dr. Prakash Marathe, sir. He is consultant ophthalmologist, Netra Yogi Eye Clinic, Pune. Sir is Senior Vice President of IMA Maharashtra State, and he is a managing committee member of All India Ophthalmic Society as well. He is also the trustee and past president.
Dr. Dipanshu,
yes.
The slide is not moving, and you are not audible in between. Please start again.
Am I audible now?
Yes.
Just stop your screen share if you can.
Actually, I'm operating my phone. My laptop has stopped working because there's no power cut. There's a power cut at my place.
Okay, now you're audible. Please continue.
Yeah, so Dr. Marathe sir is trustee and past president of Pune Ophthalmic Society and IMA Pune, and he is also the convener of National IMA, which is headquartered at Delhi. He is also the coordinator for Marathi Consent Book by AIOS and Maharashtra Ophthalmic Society. We welcome you, sir. Next upon we have Dr. Manoj Chandra Mathur sir. He has been a brilliant academic and person, and he underwent a long-term fellowship program in glaucoma. He's advisor and past president of Telangana Ophthalmic Society and Hyderabad Ophthalmologist Association. He served as managing committee member for AIOS for 2 terms, and he is also member of Medicolegal Cells AIOS 2018. Sir has been awarded with various awards like ET Selvam Award by AIOS and also the Raghavachar Award of APOS. His motto for life is "He alone lives who lives for others. The rest are more dead than alive." So we welcome all our esteemed panelists. Now we have 2 young speakers who are doing very well in their specialities. We have Mr. Suman Banerjee. He is a lawyer in Calcutta High Court, and he has done his LLB from prestigious Banaras Hindu University. His areas of practice are constitution, education, service, and consumer matters, and he has also represented NABL in Consumer Forum. Next upon, we have Dr. Nimisha Nagpal, who has graduated as well as postgraduated from Punjab, and she has done her cornea and refractive fellowship from Shankara Nethralaya, Chennai. She has done small fellowships from West Virginia, US, as well as HV Desai and Drishti Nethralaya, Dahod. And also she is a core member of Medicolegal Action Group. So we welcome both our speakers. Now I would request Mr. Suman Banerjee to share his presentation, and if we can start with his talk.
Thank you, everyone. I'm Suman Banerjee. Hello, sirs.
Welcome, sir.
So,
Please share your screen.
thank you. So, my topic is today that the Consumer Protection Act, what an ophthalmologist must know. And this Consumer Protection Act, I briefly states that this Consumer Protection Act came into being, the first act came into being in the year 1986. The earlier act has been repealed by the present act, which has been passed in the year 2019. The forums which are available to a consumer is divided mostly in three categories: the District Consumer Dispute Redressal Commission, State Consumer Dispute Redressal Commission, and National Consumer Disputes Redressal Commission. The district, these forums can be a forum of first instance, as well become appellate forum in respect of other in subordinate commissions. So I'm not and in the 2019 Act, another feature has been added, that a Central Consumer Protection Authority or Central Authority, this authority has been created by the Act of 2019. This can also take into account the complaints of consumers and make necessary investigation and refer the matter and pass necessary orders like the other state and district consumer commissions, such as payment of compensation. And these central authorities' order can be challenged before the National Consumer Dispute Redressal Commission. This since this
Mr. Suman, the slides are not moving actually.
No, I've not gone to the next slide. This is the first.
Okay, thank you.
And this concept of central authority is relatively new. So I have not come across any instance where the central authority has taken up any passed any order which has carried out in appeal before the National Consumer Redressal Commission or before the high courts or Supreme Courts. And the next part is sorry, excuse me. This Consumer Protection Act, in the strict sense, this Consumer Protection Act does not mention the doctors or the medical professionals or an ophthalmologist, to be very precise, in the act of either in the act of 2019 or in the previous act of 1986. The medical professionals, as well as an ophthalmologist, they came into the purview of this Consumer Protection Act by virtue of a judicial decision which was passed in the year passed on 13th November 1995, a 3-judges bench of the Honorable Supreme Court, where the Supreme Court had given an expanded interpretation of the word service provider, and held that a doctor who is providing service to a patient is also a service provider, and patient as a consumer can proceed against a doctor. Proceed against a doctor or the medical professional for any deficiency of service. And since since 13th November 1995, the doctors come under the Consumer Protection Act, and his or her conduct can be questioned or adjudged by the under the Consumer Protection Act by the different forums created therein. And the ophthalmologist, as I have stated in the slideshow, that the only that a patient who has availed the service of an ophthalmologist for value or money, he can only approach the consumer forum. But where an ophthalmologist has provided free service, or he has provided service in a government hospital where the patients are treated for free, that for any action for any of his action therein, his action cannot be called into question before any consumer forum. And if in any case the consumer forum holds that there is any deficiency of service, then the ophthalmologist can be directed to pay compensation which has been for any loss or injury that has caused due to such deficiency of service to the patient or as well as to the patient party.
So sorry to interrupt. Actually, I have not been able to see your slides moving. Is it still on the first slide?
No, I am on third slide.
Kaushik sir,
It's not moving.
it's not moving.
The slides are not moving, Mr. Suman. Yeah.
Can you see now?
No, I
Is
think
it-
you better use stop
It's
share.
not
and,
on the
start
slideshow
share
mode
again.
actually.
It is hang only on the first slide.
Oh, okay. Your screen sharing is paused. It's showing. Sorry.
No, we can see the screen, sir.
Can
You just
stop-
unshare it and share it again.
Can you
Stop
stop the
sharing.
screen share and share it again? Yeah.
It's showing your screen sharing is paused. I do not know.
You have to change the slides by your
Resume slideshow. Resume
laptop.
slideshow. Yes.
through
Yes,
your
yes.
laptop.
Yes, I'm through my laptop. Can
Yeah.
you see it now?
No, slides are
There is
there
a-
on
there
left
is a
side. You have to go
notification there,
on the
resume
slide
slide.
mode first. Go. You connect
Yes.
there. Now it's okay. You connect it. Go to the slide mode, and then you can go on changing the slides.
Oh, okay, okay.
There is a cup like thing. You just click that cup.
Can you see it now?
You just
Not
go
in the
to
slide.
slideshow now. At
They
the
will not
bottom.
change
At the
that.
bottom.
No, it is a
Unless you are
slide,
there.
but it is not in slideshow mode. Make it in
Yeah.
slideshow mode first. Then it will move.
There is one cup like thing.
Yes,
Just
yes.
behind
This
the arrow. So click that cup.
The resume, please.
resumes.
No. Go up, up and left. Then no. Slideshow. There is a
One thing can be done. In between, you can
slideshow.
send that.
Go to
You can
slideshow.
send that PowerPoint presentation someone who is the host or host. That person can share. That is the other chance.
Yes, I think that would be the best step. Or you can click on the second slide. Just click on the second slide.
Okay,
Yes.
I'll click on the second slide.
Yes, click on the
That
second slide.
will do also. Yes. Now you can go to the fourth side if you are reading the fourth.
No, click on the second slide. On the left column, yes, click on that. Second slide. Yes,
Now it's
Yes.
visible, right?
like
Okay.
this.
Go
Yes,
on
do it like-
changing the slide like that only.
Okay,
Yes.
okay.
Thank you.
So just a brief rewind that I said that Consumer Protection Act came into being first act in the year 1986. This 1986 act is no more now. Now the act of 2019 has come into being, and it has repealed the earlier act of 1986. In the third slide, I have said that there are 3 forums under the 2019 Act. That first is District Forum, second is the state forum, third is the national forum, and all these forums can be as in the forum of first instance, as well as it can be an appellate authority of its subordinate forum. And there are the limitations about the pecuniary jurisdiction, it says under the law, which the amount of the value of service is the determining factor for the jurisdiction of these different forums. And 2019 Act has introduced another forum, that is Central Consumer Protection Authority or Central Authority. It can also take into cognizance any complaint of deficiency of service by a service provider and initiate investigation. And if the complaint is substantiated, then it can pass necessary order directing payment of compensation. But since it's this central authority is a relatively new forum, and I have not come across any decision of this central authority which has carried out in appeal before the National Consumer Dispute Redressal Commission or any other high courts or Supreme Courts. The third part, I have stated that this consumer, either the earlier act of 1986 or the present act of 2019, both the acts do not specifically mention a medical practitioner or an ophthalmologist as a service provider, but this medical professional has been included in the as a service provider within the meaning of Consumer Protection Act by a judicial decision which was rendered by a 3 judges bench of the Supreme Court on 13th November 1995. And since then, the action of a medical practitioner, including an ophthalmologist, can be questioned before any forum which has been created under the Consumer Protection Act. Now, the prerequisite of for a consumer protection, the forums under the Consumer Protection Act to call into a question an action of a medical practitioner is that the patient has availed the services of the medical practitioner or an ophthalmologist for value, and the medical practitioner has not discharged his duties for free service or in a government hospital where the services are availed by patients for free. And if found otherwise, then the ophthalmologist action can be tested whether the same amounts to deficiency of service or not. And if it is found to be in the affirmative, then he can be directed for payment of compensation for any loss or damages that has caused to the patient for the deficiency of service. Now, the deficiency of service is basically interpreted as per the judicial decision that the medical negligence, it has been equated with the medical negligence. Now, most celebrated this medical negligence in order to elaborate this, I have to take help of a decision of the Honorable Supreme Court in the year 2010. This is the Molloy Kumar Ganguly versus Sukumar Mukherjee's case, where the Supreme Court has given 5 points. So how a case of medical negligence has to be determined by the court. The bullet points which I have specified in the slide are the tests which the Supreme Court in this case of Molloy Kumar Ganguly versus Sukumar Mukherjee has propounded. First is that no guarantee is given by any doctor or surgeon that the patient would be cured. Second test, the doctor, however, must undertake a fair, reasonable, competent degree of skill, which may not be the highest skill. Third, adoption of one of the modes of treatment, if there are many, and treating the patient with due care and caution would not constitute any negligence. Suppose there are two or more available methods of treatment who are available to the doctors for treating the patient or treating a particular disease. If one mode has been availed by the doctor and the same has resulted into failure, this will not ipso facto be declared or negligence on the part of the doctors. The fourth part is the failure to act in accordance with the standard, reasonable, competent medical means at the time would not constitute a negligence. However, the practitioner must exercise the reasonable degree of care and skill and knowledge which he possesses. Failure to use due skill in diagnosis with the result that wrong treatment is given would be negligence. It can be specified that it can be put in this way, that doctor should possess that skill who he professes to possess that skill. He should not suppose if for a particular procedure he professes that he is in possession of a certain instrument which he will use in the procedure, but subsequently it is found that he is not in, or that particular instrument has not been used in the said procedure, then the same would be negligence in terms of that disorder. Now, in the fifth part, in a complicated case, the court would be slow in contributing negligence on the part of the doctor if he is performing his duties to the best of his ability. This point can be, I can say that the courts are in the field of medical negligence. The court is a layman. The persons who will judge the action of the doctors are mostly not specified in this field. So if there are two views possible, like I have said earlier, so, and if only test that the only factor, the courts will determine that whether the doctor has discharged his ability with reasonable care. Next part, in the last webinar, it was and the last slide, which this point was elaborately demonstrated by the sirs in the last webinar. But since this also forms a part of medical negligence, lack of consent can be termed as medical negligence. For this slide, I have also taken help of a judgment of a 2008, that when the Supreme Court has held that lack of consent can also be termed as medical negligence when there is an absence of mistreatment, or when even when the Supreme Court has found in that 2008 case that the particular procedure of treatment adopted by the doctors concerned was not incorrect, but still lack of consent in that procedure, doctor was held to be guilty of medical negligence. And for that reason, the Supreme Court has formulated certain points that under what situation lack of consent can also be termed as medical negligence. As pointed out earlier, that prior consent is required before the treatment, and the consent must be given by a person who is capable and competent to consent. That means he has to be a major. If he is a minor, then his parents should give the consent. Then who has voluntarily given the consent? A person must give the consent in full sense, and he must give the consent having all the requisite information in order to have best judgment. In order to give under his best judgment, he has given the consent. Third thing, the adequate information as which will enable him to give proper give him proper consent. It means that doctor must disclose the nature and procedure of treatment, including purpose, benefits, and effects. The doctor should also disclose alternative methods of treatment, and then the doctor should disclose the substantial risks involved in the procedures of treatment. And the doctor next part, the doctor should disclose the consequences of refusing treatment. And while disclosing the consequences of refusing treatment, it is not required that it should be the doctor should give an elaborate explanation. A bare outline of mentioning the consequences will serve the purpose. Then when consented for a specific procedure, additional procedure can be undertaken only in case of an emergency. As I have said, that in 2008 judgments, a doctor has taken consent for a particular procedure, but subsequently, when the procedure was undertaken, thereafter, doctor found some complications, and with the consent of patient's mother, he preferred another operation, but for that, which was not found, the court said that the same was not an emergency, and since this additional procedure was not an emergency procedure, therefore this additional procedure, which was undertaken without a proper consent, that the same was declared to be unauthorized, and for that reason, for lack of consent, the doctor was held to be liable of medical negligence, and accordingly payment of compensation was awarded. These are my points which I have formulated. I'm stop sharing the slideshow.
Thank you, sir. That was an elaborate talk. Now I would request Dr. Nimisha if she can share her presentation.
Dr. Nimisha, are you around?
Yes, ma'am. Actually, I can't hear Dr. Dipanshu.
Yeah, maybe he is requesting you to start your screen share and start with your talk, please.
Sure, ma'am. 1 second. Are my slides visible?
Yeah.
Yes.
Yes.
Okay, I will be speaking about the legal pitfalls for ophthalmologists, most of which Mr. Suman has already covered the legal part of it. I will just be brushing through most of the important parts. Why is everyone, including ophthalmologists, need to be legally very aware? One, no one is immune. There is no limit to the compensation which can be asked for. The interest actually would be more than the compensation asked. The award may be more than the compensation, or the criminal prosecution can also be simultaneously started. 1 second. 1 second, ma'am. Are my slides visible? I'm not able to.
Yes, yes. Slides are
we are
visible
able to
and
see the
moving.
slides, Nimisha.
Okay. So the legal problems for all doctors, including ophthalmologists, can arise under various laws. The allegation of negligence can be covered under CPA, under the criminal law, under IMC Act and the Article 32 and 226 of the Constitution. There are other acts under which, other laws under which this we can have legal complications like Clinical Establishment Act, Commercial Use of Residential Premises, Biomedical Waste, Air Act, Water Act, Labor Laws, ESI, Provident Fund Acts, and Workplace Violence. Sir has already covered this. I will just go through basic stuff. The CPA of the 1986, which was a VP Shanta 1995 versus IMA, this judgment clearly states that it was not possible to hold that in view of the definition of deficiency contained in the section 2 of this act, medical practitioners must be treated to be excluded from the ambit of law. Having this regard, in the VP Shanta's case, the Consumer Protection Bill, which in 2018 expressly included healthcare within its ambit. However, the new proposed definition was met with a lot of opposition in the parliament and the bill could not be passed. Yet another bill was introduced in the parliament. This time around, they did not include healthcare in the services. But there was a trick here. So in 1986, the service included banking, finances, etc., and all which included healthcare in this definition. The Consumer Protection Bill in 2018 actually had healthcare in the definition, which was not, met with opposition, so it could not be passed. In 2019, they actually did not include healthcare in the definition, but they did not include it in the exclusion criteria. There was a word named services and others, including all these services and others. So we falsely fell into the category of the others. That was the loophole. So major differences between 1986 and 2019 CPA are that there are increasing number of cases filed for compensation due to ease of filing. There is e-filing, there's video conferencing, there is you can sue it at your hometown, there is no fee of services paid up to 5 lakhs, and more importantly, no penalty for frivolous complaints. The exorbitant compensation being awarded by increasing jurisdiction of consumers can go up to 10 crore and actually have been awarded. So there are two legal terms that I will be discussing here. There is one, a contract of service, and there is one, contract for services or for personal services. Contract of service is a professional that is obliged to obey orders in work to be performed and is to be a mode and manner of performance, which means a master-servant kind of a relationship. What the master asks, the servant will do. Whereas the Honorable Court states that the contract for services implies a contract where a professional uses his knowledge and discretion to decide what is to be provided. Healthcare falls in this category. It basically gives services and they decide according to their knowledge and discretion that they decide to do whatever they do for the best of the patient. Like Sir had just described this case, that another procedure was done for that patient. That another procedure was hysterectomy, which was done for a frozen pelvis, endometriosis. The doctors felt that the patient was already under general anesthesia and they wanted to do the procedure. They had taken consent from the relative of the mother standing outside also. But this did not hold right in court. They said that as it was not an emergency procedure, they should have waited for the consent of the patient itself. What is the problem under CPA? One, there is no limit to what compensation can be asked for. Consumer Protection Act 2019 has made asking for compensation in crores acceptable, and it's actually being accepted. 2019 Act has made easier to claim compensation, hence increasing the number of claims which will be filed now. Are Indian ophthalmologists immune? I really don't think so. So there are a few examples I'll be discussing here of legal complications in ophthalmology, which are very few out of the rest. That is more important. The list is ROP, delayed response in systemic associated diseases, eye camps, use of off-label drugs, cosmetic surgeries, which have very subjective outcomes. Retinopathy of prematurity, the compensation for loss of vision in this case, which was a judgment in Supreme Court of India in 2015, was 2 crore 28 lakhs. though this case was not against the ophthalmologist, but in fact that the loss for vision, the quantum of compensation can be awarded as this much under CPA. This patient was a dengue patient. The complainant was admitted in ICU in the outpatient hospital for treatment for dengue. Around 6 p.m. in the evening, he felt there was decrease in vision and loss of eyesight in both the eyes. The complainant was left in the ICU of the OP under care of the nursing staff and the junior doctors, who were not competent to take care of any eventuality and emergency. Next day, 7 a.m., the ophthalmologist actually came and advised for MRI, which revealed microbleeds. The patient was treated with IV methylpred and eventually did gain a bit back of the vision, but after multiple complaints were made to the Chief Minister and the Registrar, Delhi Medical Council, around 35 lakh was compensated for this. We are very, we know this practice of ours of using off-label drugs. This case, particularly in 2018, the complainant had problem in the left eye and was advised IV Avastin, which is trade name for bevacizumab. As per the advice, the patient took the injection in February 2014. On the same day, his eye started watering and severe pain and redness. Later on, the various treatments, including vitrectomy surgeries, intravitreal injections, and multiple consultations were done free of charge. Further, medication was also given free of charge, which is another red sign. Basically, what had happened was, after the intravitreal injection, patient would have developed endophthalmitis. There were 8 other patients who had developed similar infections, which had occurred after the use of the single vial of that one Lakshmi Medical injection of Avastin. The lab report of that injection showed huge quantities of Pseudomonas and Klebsiella in the drug. The FIR was launched and a complaint to the Director General, Drug Control was done, where he clearly stated that the drug was contaminated, due to which the patients operated, due to which this complication had occurred, and to take, they requested them to take the necessary actions. The ROSI's position was very clear. The Drug Controller General of India had issued an alert notice to the state regulators that this drug, Avastin, is an off-label use to treat eyes. It is not approved in the country for intravitreal use, and the treatment is actually for colorectal cancer. So thus 5 lakhs was awarded in this case. This actually comes under medical negligence. If we use it in an off-label treatment. There were other cases in 2016, similar cases, even after the alert was given out. 7,000 patients in one hospital, Nagari Hospital, 15 patients, the Sri Sundara Lal patient. After the alert, also 5 patients lost vision following the injections. We basically love eye camps. This practice of doing a lot of surgeries in short number of span actually can get us into a lot of problem. There's this judgment in Madras High Court 2018. On 2008, around 66 patients were operated from 7 a.m. to 3:30 p.m. at Joseph Eye Hospital, Perambur. On that night, most of the patients complained of excruciating pain in the operating eye. Next day, we were given treatment, and 29 of them were shifted to Trichy Hospital. 61 of them, out of 66 patients, actually lost the vision. 5 partially lost the vision. Public went on agitation, seeking for compensation and action against hospital management. The public interest litigation was filed in the High Court Madras. CBI filed a final report against these 7 people for offences under Section 37 and Section 325 IPC. The CGM found no evidence to show existence of mens rea to voluntarily and intentionally cause hurt, but material disclosed prima facie case for offence under 338. Basically means causing grievous hurt by act, endangering life or personal safety of others, and of IPC was made out. So even if a hospital is treating patients for free, but if the part of the hospital is paying, is taking payment from some patients also, they do come under CPA. Most of these eye camps are free of cost. We basically give them, do surgeries free of cost. But if that hospital does surgeries which actually take payment from other patients, then they do come under the Consumer Protection Act 2019. The trial court held 2 doctors and the chief administrative officer of this hospital guilty of offense. Sorry? Okay.
No. Sorry for the interruption. You can
Can I
continue.
continue? Yeah. Okay. The trial court held 2 doctors and the chief administrative officer under Section 338 IPC and sentenced 1 year simple imprisonment and pay a total sum of 2 crore 75 lakhs. They also certain direction were also given to the authorities, including Medical Council and District Blind Control Society. This in Sessions Court, in Trichy dismissed the appeal which was made and also enhanced the compensation from 2 crore to 9 crore. So this also can happen. The patients were actually found to have endophthalmitis, which was the eye got infected by Pseudomonas, which is a very frivolous infection. But the doctors who conducted the cataract operation were not found guilty. Because there was no proof of gross negligence. But the directors and the administrative were held guilty since they were persons administrating day-to-day activities, but they were not present at the hospital. So what was the problem here? Dr. Nelson, the director of the Joseph High Hospital, did not get approval to run the hospital at Perambur. Second, there was no consent obtained from Tamil Nadu Pollution Control Board for running the hospital. Third, there was no proper design or maintenance of the operating room. The sterilization and room and the separate room for storage of medicines, all this should be under care of at least the doctor who is operating. They did not appoint any anesthetists, but utilized services of the ophthalmic technicians for the same. They did not appoint any pharmacists as required under Drugs and Pharmaceutical Act. Also, no preoperative tests were done. There's another case, which is Saurabh Saini versus New Delhi Center for Sight Private Hospital on 10th of May 2018. The refractive surgery, as we know, is has very subjective outcomes. So this patient underwent refractive surgery and got a toric ICL at Center for Sight, New Delhi. After the surgery, the complainant suffered blurring of vision, headache, and infection. He claimed compensation of 6 crore. The opponent one had carried out some discrete inquiries and had come to know that after LASIK treatment, he had completed his higher education. He had presently being fully employed and he was doing very well. The unrealistic claim had been made only in view of conferred procurity jurisdiction on this commission, which cannot be permitted. So, therefore, without commenting on the merits of the complaint was dismissed. In short, that the patient actually, this complaint was dismissed in a way that the hospital did good homework, did good study, took good steps to find out that the patient actually had a normal life. Thus, the court had no way taken the side of the complainant. What are the legal pitfalls? So there are 5 major legal pitfalls we need to be sure of. 1, before treatment, what we do. During treatment, how we do it. After the adverse event, how to react. After receiving legal notice and in court. So preoperative tests in ophthalmology. There's an article, Medical Tests Before Eye Surgery, when you need them and when you don't. It was published in American Academy of Ophthalmology 2017. Even though we know that eye surgery is a very low risk, many healthy patients get a routine set of investigation before the surgery. Necessary tests are done so that the competent doctor examining, like a physician, can verify the patient is fit for surgery. What are the mistakes we do before the treatment? One is very important, consent. What are the problems with the consent? 1, not taking the consent at all. Second, taking consent from a relative instead of from an adult, competent, conscious patient. Third, not taking informed consent. Like, for example, I'll explain later in some examples I have quoted, but we tell them about a procedure, we do not tell them about a common complication. That is not taking informed consent. Taking partial consent, doing something more than what the consent has been taken for, like an additional procedure or additional procedures. Doctor not signing the consent is also a very important mistake. Not taking refusal of consent also. It is important to take refusal of consent in these most cases. What mistakes do we do before treatment? Consent not taken for common complications. Like for a LASIK surgery, a patient had claimed that the consent was taken for LASIK surgery and informed consent was not taken, that she was not told about the complication that could occur. 1 crore compensation was demanded for stria which developed in cornea flap after this LASIK surgery. And we all know it's one of the very common complications. But as the patient was not told, even if he was told, it was not documented very well. This was actually in favor of the complainant. Problems of indemnity insurance. What are the problems? Either we don't have it, there is no indemnity insurance, or sometimes we take personal indemnity insurances. Sometimes the indemnity insurance is inadequate. The cause of onset is prior to the date of the policy, and there's careless filling of proposal forms. Here are some examples like indemnity insurance taken by doctor to operate in one center but operated in another center. This doctor had taken consent, this insurance to be in one hospital, but he went and did the surgery in another hospital as part of the free camp and developed traumatic vitreous hemorrhage and anterior hemorrhage later. The insurers denied responsibility because the doctor had mentioned only his clinic in the proposal form. Cause of action prior to onset of policy. For example, we have taken, in this case, they had taken the insurance from 22 November 2020 to 21 November 2011. But the operation had occurred on in March of 2010. Hence, the insurance company was not liable in any matter. What are the problems in documentation we have? No documentation at all. Either we have incomplete documentation. Abbreviation is something which we use very commonly and we should really avoid in all documents hereforth. Unsigned documents. Documentations but records are not stored properly and delay in such cases. I'll give you an example of an incomplete prescription. In this case, this is Devinder Singh Gupta versus Dr. Vivek Pal in 2013. This post-surgery of pterygium, query OSSN, due to pain and irritation, advised him to use mitomycin, but committed a grave mistake. He did not prescribe the medicine for how many days? The appellant, instead of coming back for a checkup, which was mentioned in the document, but continued using mitomycin, which led to damage of the eyes. A compensation of 50,000 was awarded as limited negligence. Contributory negligence of the patient is continuing to take medicine on his own without consulting the doctor. So it was a part negligence on our part. We have to be very sure of writing the duration of treatment also. There was a case of ROP screening. Where there was no proper medical documentation of ROP screening done. The opponent should have performed, according to the court, proper retinal examination with binocular IDO on dilatation of pupil with scleral depression to a certain avascular zone at peripheral retina. All retina surgeons or ROP surgeons know this. But in the medical record, it was not written as such. It was just written, for example, ROP done. Probably that was the only thing which was written there. But in court, it was not valid. The medical record which was done had no clear definition of what was done, where was the avascular area, what was the peripheral retina like, nothing of that sort. So in view of court, they had neither performed ROP nor advised for follow-up. Basically, they thought that in haste to cover up, they have just written or added that document. 64 lakhs was awarded in this case. Abbreviation should never be used. In this case, which was Medical Director Amrita versus Unikrishnan NCDR, 9-year-old child underwent ophthalmic surgery for squint. He suffered cardiac asystole towards the end of the surgery. Successful resuscitation was done, but the patient did not succumb in the ICU. NCDRC concluded that 1, consent obtained from the mother of the child was just a routine consent and not really an informed consent, telling them about the complications of anesthesia, about the complication of surgery. Furthermore, although the anesthetist claimed that the retrovalvular block was given, but documents did not corroborate it. Third and very important is that glyco word was used multiple times, whereas instead of glycopyrrolate. So it was confusing, and it was like a confusing apprehension to in medical records is deficiency of service. One very important legal pitfall is jousting. Jousting is an unfortunate practice of health practitioners making critical comments of other patients, another provider's care, directly or indirectly, either to the patient or in medical record. Such things like doctor called repeatedly, ignored, horrible scar of previous surgery, no nurses available to help, should not be anywhere documented in your anywhere in your documents. It would just land you in trouble. What do you do? What are the mistakes following an adverse thing? You try to cover it up. Either you have an improper communication. If you do a resurgery, you should be equipped for the same, and you should take proper consent for it. What are the pitfalls after receiving legal notice? You should try and have a compassionate settlement out of court. That is the best way out. Try to give all evidence in the initial stage, because that is where you can actually improve your case. After that, it just helps, it just adds to cover ups. Try to hide the issue. Do not, trying to hide the issue from your colleagues never helps. Always file average practicing colleagues of your specialties affidavit so that it comes in favor of you. Very important.
Dr. Nimisha.
Yes.
Hi, sorry to interrupt. Actually, if you can give us a list of we are running little short of time.
I can't hear you, sir. Sorry.
He's saying you need to wind up your talk. We will
I
have
am.
this.
I'm done.
Yeah. So if you can wind up in next 1 minute, that will be good.
Okay. Pretty much that's it, ma'am. This is more importantly, this is one case I would want to really say that post-cataract surgery, you have to, post-operative instruction should be very clearly given to patients. In this case, one patient underwent cataract surgery. He was not suggested rest. So patient was a coolie by profession. He developed corneal injury due to working in his fields. He should be he basically should have been instructed about post-operative care and follow-up. The medical record was devoid of such, so compensation was given. That's about it. Thank you.
Thank you, Dr. Nimisha. It was an excellent talk, and you have highlighted all the examples very well. Now I would
really
request.
Can't hear you, sir.
Can you hear me now?
Dr. Dipanshu, are you there? So anyways, thank you, Dr. Nimisha, for the excellent talk. And we have with us 3 seniors. So we would like to hear their comments as well. So Dr. Deshpande, sir, if you would like to comment something on both the talks.
Yeah, the comments on this is that the thing is that the Consumer Protection Act is basically not made for doctors, medical health care, because when it was drafted, it was in front of them was the builders and the traders. That's why they limited the limits on production of the bill in the consumer protection commissions. Nowadays, it is not. It is called as a commission: district commission, state commission, and central national commission. And 1 crore is the limit for producing the bill for the district commission. So it means that every case should come to the district place only. Another thing is that the Consumer Protection Act 19 is the two-way it is defect challenging to us. That is, one thing is negligence and another thing is substandard services, and that is a product liability. So these 2 things are there. Apart from that, there is a central authority which can intervene you and do the inquiry and put the cases. So all these things are there. When these all things are there, the doctor should be very cautious and should have a good indemnity insurance. And to be frank enough, what happens, one doctor can have their own indemnity insurance and can operate in any hospital, it doesn't matter. But the hospital should have an indemnity insurance to cover when the case is lodged on the hospital. So both the things should be there. There should be indemnity insurance of the hospital and indemnity insurance of the doctor.
वेबिनार चालू आहे आरतीने आता
Any questions are there?
Yes, sir. Can we have Dr. Marathi, sir? If we can.
Yeah,
Like,
yeah. So thank you for the invitation. Basically, I would like to point out three things. When this CPA Act 2019 came into existence, 3 points. There were 9 prominent features that were new in the 2019 CPA Act compared to 1986 Act. Point number 3 relates to misleading advertisements. So I'm going to just brief you about these 3 points. Point number 3 relating to misleading advertisement. So what we need to take care is we should not falsely promise anything to the patient beyond the purview of what is reachable or what is, as Nimisha pointed out, we have to be very clear as to what should be the expectation from the patient. Point number 5 relates to the pecuniary jurisdiction, as Dr. Deshpande also said. Like at the district forum, it was, the limit was 20 lakhs earlier, which is now raised to almost 1 crore. And at the state commission, the limit is raised from 1 crore to 10 crores, up to 10 crores, and at the national commission to over 10 crores. So this is one pecuniary jurisdiction change. And the point number 8 is very important. The new CPA Act involved the formation of consumer mediation cells. So any case can be referred to a mediation cell with the consent of both the parties. And the catch point here is like, though you have the liberty to walk out of the mediation at any point, but if you accept the mediation and based on that mediation result by the mediator, if the court pronounces a judgment, you don't have a right to appeal and go up further. So these are the 3 basic things. So what is required from our side is, as Nimisha pointed out about, we should take adequate indemnity insurance. And when we are taking adequate indemnity insurance based on our risk profile, what is needed, 2 important things for us to know is 2 abbreviations, AOY and AOI. AOI is any 1 year is AOY. So any 1 year, the limit is, say, suppose you have taken an insurance for 1 crore. AOI is any one incident. Like one insurance agent may come and give you a policy, say you will be covered 1 crore, you have to pay only 16,000. Another will come and say you will be covered for 1 crore, but you have to pay only 12,000. How to read between the lines with these 2 proposals is any one incident. Suppose if your policy between the lines says AOI 25%, that means though you have indemnity of 1 crore, but for one incident you are covered only up to 25 lakhs. That is the reason why the premium is less for that particular proposal. That we need to understand. And the second thing is, most important thing about the indemnity insurance is the correct time of renewal of your payment premium. What happens is it has a retroactive date. And unlike the endowment policies or unlike the LIC policies that are in vogue, you have 1 month grace period to pay your premium. Suppose if the premium is due in August, you have a grace period of 1 month. Up to September end, you can pay your premium. Whereas for indemnity insurance, you have to pay before the due date. If you pay after the due date, there is no grace period. The retroactive date changes. What the clause clearly mentions is the insurance cover should be present from the date of insurance till the date of filing of the petition. So if you have a break of insurance in any of the years, suppose the incident has happened in 2020, and in 2021, while renewing your indemnity insurance, you have paid 1 week later than the due date. That means your retroactive date comes through 2021 and not you won't be covered for the incident that has happened in 2020, though the date falls within the 2-year range of your Consumer Protection Act limit. So these are the things that we need to be very vigilant about, take care and take adequate precautions and policies.
Thank you, sir. They were very good points. Actually, we have some questions from the survey which we had circulated. First question is from Dr. Kaushik itself, that do ophthalmologists fall under the jurisdiction of CPA? So,
of course, ophthalmologists are coming under CPA. Before that, I also wanted to comment about Consumer Protection Act. All the topics are very well covered by Advocate Dr. Suman Banerjee and Dr. Nagpal. Both the talks were fantastic. About Consumer Protection Act, few things I like to just comment. That first thing, when this Consumer Protection Act 2019 came, medical fraternity was very happy and thinking that medical profession is not under CPA. But that was not correct. I explained in both the talks, because it was not there in the exclusion list. Unless it comes in the exclusion list, medical fraternity will be under CPA. Second thing is compensation is increased. It is going to crores and more than that. But one important thing which is linked in this Consumer Protection Act 2019 is it has to be linked with the bills. So as per bills, and ophthalmology bills many a times are just at and around less than lakhs. Third important thing is jurisdiction anywhere in India. Suppose you are operating the patient in Mumbai and the patient is staying in Chennai, probably he can file the complaint against you in the court of Chennai. Previously, it was the jurisdiction where the doctor is practicing or the hospital was situated, and that was the jurisdiction. Nowadays, that worst thing is happening, that the territory, jurisdiction can be there where the patient is staying. And you have to run away for the cases if they are filed against you in the various states of India. Next important thing, what Dr. Mathur has already mentioned, there is provision of consumer mediation cells, and that is good and bad as well. Because good in the sense you have got a chance to come out of the case by that mediator cell. Another thing is that there are agents, there are agencies, they're just working on this and trying to push medical fraternity, doctors and hospitals, and just bad role of those particular agencies can be played. And apart from that, what question was asked, that ophthalmologists, of course, they are under Consumer Protection Act. Next question.
Thank you. Thank you, sir.
Dr. Marathe, I would like one clarification probably from Dr. Deshpande or Dr. Marathe. Dr. Marathe said that the compensation is related to the billing. Is it true? Like billing up to 5 lakhs, they don't need any payment to file a case. But I don't think, suppose if the cost of IOL surgery was 20,000, the compensation will be up to this point, or the cost of IOL surgery was 1 lakh, the compensation will be more. Is it true that the compensation is related to the payment by the patient, or that is independent?
Yes, it is not related to the bill, but there is a relation of the bill. If it is a below 1 crore, the case will go to the district commission. If the bill is more than 1 crore, then it will go to the state. So normally in any ophthalmic surgery or any ophthalmic hospital or in other hospitals also, generally bill is not more than 1 crore. So all cases will come to the district commission. Another second thing I will say, what they have done, that not limited to, this word is added before the services in the clause. So all the services are included under the Consumer Protection Act 19. So they have positive and negative lists, that is true. But apart from that, they have added one word, and the services, and not limited to the services. So not limited to is the word which brings all type of services in the preview of the Consumer Protection Act. Another thing is that the mediation sale, as Dr. Marathe said, it is bad too, because nowadays I have seen in many cases that the advocates of both sides compromise each other and put the frivolous case and contribute the money by doing the mediation. So this practice should not increase, otherwise both will be troubled.
Here, what basically happens is like we take an indemnity cover, and the insurance who is representing us when we are taking the insurance cover is the insurance company. They would like to wind up early. They would like to settle out of court. They would like to insist on mediation. They represent us on our behalf. And when they settle for the mediation, there is a two-way loss for us. Number one, your indemnity gets exhausted. Number two, your reputation is at stake. You may be right, but the insurance company imposes the mediation on you. So that is one disadvantage of this mediation.
Yeah, that's correct.
Next question. Yeah.
Thank you, sir. Sir, so another question we have in the chat box is, who decides the expert panel for determining the presence or absence of negligence?
The expert panel is at two places. At district level, civil surgeon appoints an expert panel and gives the opinion. But at one can ask for the medical board, which is situated at a higher level in medical college. So every medical college is having a medical board, and that medical board decides the negligence is there or not.
One thing I'd like to add here, most of the times these particular committees that have been asked those questions, they are like yes or no format. So there is no explanation asked for. And sometimes that yes or no is treated by police authorities in their own way. So even if the meaning is different, the question is asked in the format yes or no. Do you feel that negligence was there? Something of that sort. So yes and no, it is confusion from that expert committee what to write. So that misleading questions in yes no format are going against medical fraternity.
Okay, sir. Thank you. So next question is, what are the rules about reuse of items like tubings and tips medico-legally? Are we allowed to use it, or do we need to change it for every case? This is from Dr. Mandar from Pune.
Yes, about the tubing, the tips and the instruments which are going inside the eye cavity. The instruments which are going in the eye cavity should be sterilized, and the sterilizable points, sterilizable covers can be utilized again till they are effective. But for tubing the purposes, because there is a one-side flow, the other it cannot come back unless there is something wrong in the instrument. So infection cannot come from the instrument to the eye, only the flow is from one side. But that also requires regular servicing, changing of the tubes regularly, and maintenance of the equipments.
I think it is the onus on the doctors and hospitals and the surgical unit that you were careful enough for sterilization of your equipment. Suppose there is no infection, probably no case will arise. But suppose there is a case of infection, and if there is, if the case is going in the court of law, probably you will have to prove that you were taking proper care. And if you are not able to prove that the proper care was not taken, probably the person may get penalized.
Thank you, sir. So next question is, what is the time limit from surgery within which the patient has to approach the consumer forum or court for medico-legal cases?
2 years.
Dr. Madan Gopal from Tamil Nadu has asked this question.
The time limit is capped 2 years.
2 years.
But I got some addition in that.
But
suppose it is 2 years, patient also can say that I was not knowing about this, I came to know afterwards. So courts, they give exemption to the patient and relatives. So after 2 years, suppose they are filing the case, still it is considered. Dr. Deshpande,
I will add to this another thing, that from the date of cause of action. So when the patient comes to know that something has happened with me, that is the date, and from that date 2 years. But the magistrate or the judge have an authority to give 1 more year with the pleading of the advocates for some reason, for particular reasons which are agreeable to the courts. So it becomes 3 years from the cause of action, and the cause of action may be anything, any date from the surgery.
One more thing in case of pediatric cases, when the child attains the age of 21, so till that time the child has got liberty on his behalf. Suppose parents have not filed the case when the child was of that particular age group. When he or she becomes adult, that person can file the case at that time. So the
After
limit of 2
21
years
plus
doesn't
3.
work there. Yeah.
And also there is no time limit for criminal negligence. So that's the reason why, though the time limit is considered 2 years for CPA Act, we need to preserve our files for at least 5 years.
Lifetime.
In fact, as Dr. Marathe said, if it is a pediatric case, probably till the child attains majority of 18 years.
And if it is the criminal case and medical legal case, you have to keep those documents lifelong.
Thank you, sir. Thank you for highlighting those points. Another question is from Dr. Saurabh Shah from Gujarat, that there is liability of doctors doing jobs in corporate and under private hospital. Are there any terms and conditions that we need to mention in the contract from protection against the CPA?
As such, there is a Supreme Court decision and the National Forum decision that when a person is working in some other hospital, the hospital is the service provider to the patient, and patient is consumer of that hospital, and the patient is paying to the hospital and not to the doctor. Though the money may be going to the doctor as a share or as a payment or pay, but doctor is the service provider to the hospital, and hospital is the consumer of the doctor. So this is a triangle. So whenever the operation is being done in a hospital, whether charitable hospital, corporate hospital, or a private hospital, or individual solo practice hospital, the patient has come with the name of that hospital and he is paying the money to the hospital. So the hospital becomes the consumer, the patient is consumer and the hospital is service provider. So according to this decision of the Supreme Court, doctor can have a relief from the case immediately, saying that I am not, this is not my consumer.
Just to add one thing, there is like vicarious liability, and most of the hospitals, when such thing arises, probably they do not support doctors. They also try to take doctors in that particular case, and because of that vicarious liability, just you cannot be left out. So be careful whenever such case is there. Most of the times, the doctors, they are not supported by corporate hospitals and big hospitals.
Exactly. This is what I wanted to say, the issue of vicarious responsibility for the hospital. And this also applies to the specific case that Nimisha mentioned earlier, that the doctor was held responsible and insurance was denied because that surgery was performed in a camp, because that camp will not have its indemnity cover. That is the reason. Otherwise, as surgeons, we are entitled to operate anywhere in the country for our individual indemnity policy. Yeah, though our address is mentioned, there was address of your surgery is mentioned. But if you are operating in any other hospital, that hospital, if it has an indemnity cover, you do get a cover. But if that particular place where you are operating does not have an insurance cover, like she said about a camp, then the insurance will be denied to you.
All right, so thank you, sir. So another question is from Dr. Pooja KV from Karnataka. Like, what all precautions do we take when we are operating high volumes in cataract camps? Like, we are operating cataract surgery in cataract camps, and if there are patients who have previous history of cardiac heart attacks, or if they are cardiac patients, so how do we go about those dealing with those patients and protecting ourselves in those scenarios?
Really speaking, high risk patients are not operated in the camps. They are referred to the hospital, and with proper care and proper investigations, they are operated in the hospital. Camp is a place where the high risk patients are not entertained. Secondly, the camp organizers are responsible for everything, because doctors have no control on sterilization, camp arrangement, cleanliness, and all the things except the surgery, because the complication cannot be the same for each and every patient subsequently. So doctor cannot be blamed. And same thing happened where I inquired the indoor cluster infection episode, and I given the reports, and accordingly all the doctors were out of consumerism or other allegations or criminal cases, and the hospital was blamed for that, for conducting the camp, and not the doctors.
About the camps, I think in the past, maybe 20, 30 years ago, the camps used to take place even at school premises and small rooms where it was getting converted into operation theater. But these are not the days. Nowadays, whatever surgery you have been doing, may the patient be poor or high class patient, and whatever the surgery you are doing, maybe in the ICAMP or in corporate or big hospital, the quality shouldn't be compromised. What the court says most of the times, whenever and wherever you operate with the patient, if the quality is compromised, probably the negligence is proved. So when the problem is not there in the camp, probably you are not held. But when there's cluster infections occurring in the camps, probably everything is questionable. So nowadays, the camp organization by various charity organizations with low grade setup, like in the schools and small setups, is being avoided. So better, I will advise new generations not to go in such camps and don't put yourself in trouble.
Thank you, sir, for highlighting that point. So another question we have from the chat box from Dr. Indivar Mishra is that Indian system is somehow going the American way in terms of legal difficulties for the medical practitioners. How are the American doctors protected, and what policy of theirs is different from ours?
Before the experts say, I'll just add one more thing. Even in America, one difference is there apart from India. In the past, the compensations in India, they were in lakhs of rupees. Nowadays, that Kolkata case, it started going beyond crores, and it was 11 crore. Of course, it was divided with the doctors and that hospital. So the worst thing Indian legal practice is being seen is that there is no capping. This is important thing. In India, we must have a capping on this compensation. All basic organizations like IMA and ophthalmological societies have been trying, and they must try. Even legal experts like Dr. Deshpande sir, they must try that there must be some capping on this compensation. What I heard, probably experts will be able to tell, even in America, there is some sort of capping. Over to you, Dr. Deshpande sir.
So now the capping can be achieved by putting a PIL, public interest litigation, in Supreme Court only. If all organizations come together and put a case for capping, that can be discussed by the Supreme Court, and that can be ordered by the Supreme Court for the capping. Because nowadays, the cost of the damages is according to the life of the patient, the futures, if the child is there, what he will be, and how much he will earn, and what will be his future, and accordingly the calculations are going, and on that interest, so the amount is becoming very high. So there should be some criteria fixed by the court, and there should be capping for every case. That is, case to case capping should be there by the courts, and that can be ordered by the Supreme Court only, and nobody else can do it.
About the question, what system is followed in America, and how those doctors are facing this particular challenge.
All right, sir.
In America, capping is not there, and the thing is happening, if the insurance has taken by the doctor, the insurance premium goes on increasing as he gets more and more cases convicted. So naturally, the cost of the treatment increases to the patient.
Okay.
Dr. Dipanshu, we do have a question in, we have some
Chat box. Yeah.
have
Dr.
it
Manish has
as-
asked that who makes a reasonable judgment that this is a routine complication versus medical negligence?
As such, okay. Somebody is speaking, let him. Yes.
Yeah, basically it is the forum, the commission chairperson, they have to take a call. Like that's why even in the recent case of Tamil Nadu, where a compensation of 1 crore was sanctioned for a squint surgery about the oculocardiac reflex, like basically like sometimes a proper expert panel opinion is not taken, then that is taken as a sort of it is construed as a negligence on the part of the surgeon without going into the technical details, because the judge doesn't have that depth of medical knowledge. So ultimately they are the people who make the judgment. So it's
I will
a
add to it. I will add to it. The basically all the complications mentioned in the textbooks, journals are not the negligence. Negligence is that when you don't understand the complication, you don't take the steps to rectify that complication, or you don't refer the patient to a higher center if you are not efficient to tackle that complication. That is the negligence. So whatsoever consent you may take, you are not away from the negligence, because the consent is taken for all possible complications, and consent is never taken for the negligence. Our AIOS has formed the consent booklet, which is a specific consent for specific surgery. This telling everything about from the alternative surgery procedures and complications and those all the things, and that can be followed, and that is also converted in Marathi, Hindi, and other few languages also. So if you take the consent on such a paper, it is probably the doctor is more safe, but the medical legal consultant is the more important, who can put the way it's the case in front of the judges, that because judges may not be a medical persons to understand all the things. So you have to show the judges that the complication is different and negligence is different.
I think that question was asking about who takes the decision. I think it is the bench of those particular people, and it's a judge. And if they do not understand that medical language and medical terminology, they take the opinion from expert panel. And that way, what they understand, they are taking the judgment.
All right, sir. Thank you. Dr. Indivar Mishra wants to ask a question to the panelist. Sir, can you unmute yourself and put your question forward?
Can you hear me well?
Yeah, please. Please go ahead.
Yeah, there are two things. Now, Dr. Nagpal mentioned one thing, that we need to take a second consent for a second surgery. Now, suppose I'm operating on a cataract patient and I do happen to have a nuclear drop, and the retina surgeon will be probably visiting in another 2 or 3 hours. So do we need to take a second consent for such a case?
Can I answer that, sir?
Yes, anybody answering?
Yes.
Sir, actually, yes. We had a similar case that Mr. Suman also had described about that patient who had to undergo, the doctors decided to undergo an hysterectomy. For our ophthalmologists, in our cases, if there is, for example, a rent and there is a nucleus drop, we cannot go ahead with that surgery. According to CPA, we should stop the surgery, take a second consent. Informed consent is the important word. Tell about the complications, explain it in detail, then make the surgeon who is going to operate on the patient for retina surgery meet the patient, then go ahead with surgery. We end up doing things in the patient's interest, but this actually backfires on us. We should not, it is very important, it's very well written in a few judgments that they take consent for a patient, for a different doctor, and a different doctor operates. That is also one of the terms of medical negligence. So we cannot do it. For the second procedure, we need proper documentation.
Very well answered by
TCR is a,
Nimisha.
sorry, sir.
But one more important thing is that when you are taking the consent, and when it is an informed consent, you must tell these likely complications. Suppose you are told about this likely complication to the patient, probably it becomes easy when you do that surgery second time. And that time, the patient and relatives are giving you the consent and saying that this operation can be done. But what she has mentioned is the perfect thing. Informed consent in detail with all the complications known, you must tell to the patients and relatives. Don't hesitate that this cannot happen. You can tell everything till death almost, that nobody will like to read that consent and sign. Even you yourself, when your home means family patient relative is there, you will not like to read that consent and allow the patient to operate. But then still it has to be done as doctor because you are in different shoes.
And one more thing, like about the complications immediately after the surgery, you need to inform the patient if at all any complication occurs. Suppose you may get a small PCR, but that PCR, if you don't inform the patient and if subsequently that patient ends up in cystoid macular edema and ultimately gets a substandard vision, the very fact that though you have mentioned in the medical record about the PCR, but you have not informed the patient about PCR, that constitutes negligence.
And always, I always say in my talks, that is promise less and deliver more. So about the complications, while taking the consent and that to inform consent, tell many more complications, whatever you know. So that suppose that complication doesn't occur, patient is very happy. And by chance that complication occurs, patient and relatives, they feel the doctor has explained everything to us beforehand.
Sir, PCR is a known complication of cataract surgery. Can a blanket consent be taken that in the event of a PCR and a nucleus drop, another surgeon might intervene? Can we do that? Is it allowed? Is it recognized?
If you are intervening directly, if you are a vitreoretinal surgeon, then even then also you should have a informed consent separately for that. Already you have, if you gone through the consent booklet of the AIOS, there is a mentioned complication that the nucleus drop can happen. And the nucleus drop, if happens in second surgery, will be required to remove that nucleus by the vitreoretinal surgeon. So already these things are there. But if the complication mentioned actually takes place, the patient should be again informed and taken the consent that another doctor is going to operate for this because he is expert in that technique.
Okay. Sir, electronic medical records have become the norm.
You yourself is not VR surgeon, and suppose the way you are asking that question, probably all the time VR specialist is available to you in your setup.
Actually, yes. Yes, sir.
Okay.
So even if he is available at hand, still the consent is required that the other doctor is operating.
Okay, sir.
There is a question from Dr. Devanshi Shah on YouTube. We have discussed this in details in last webinar, sir, but if you can repeat it. How many years do we have to save the documents and consents? Also, can we save it in the digital format or physical papers are essential?
The documents should be saved according to Consumer Protection Act, 2 years inpatient documents, 3 years for outpatient documents. According to the Limitation Act, Civil Limitation Act, all the documents should be kept for 6 years. According to the Income Tax Act, you have to keep the document for 6 years. And according to the child, that when he becomes the major, that is up to the age of 21 and plus 3 years, that is 24 years, you have to keep the document. Now, how it should be kept is a problem, but it can be saved very easily nowadays, which was a problem previously. Because in old days, one has to keep the all record in record room and keep the documents there. Now you can keep the documents as a record for few years, but you can scan every document and put it on in your computer. Scanned documents cannot be changed. And so whenever it is required, you can have a printout, sign it, and give it to the court or wherever it is necessary. But when you put the documents in the Word form, they may not be believed, because in the word form there can be changes done, and that changes may be done by at any stage and anywhere by anybody.
Just to add about medical legal cases, all the time throughout your life, if there is a criminal case, all those documents must be kept forever. So just remember that. Don't discard those documents
till the Supreme Court decision comes.
Yeah.
All right, so thank you, sir. Another question is from Dr. Prem Kumar. He's asking that if he's there, he can ask this question directly. What about diagnostic eye cams?
So diagnostic eye cams can be taken in any place with the permission of the local authorities, that is civil surgeon or the district health officer, and proper investigation facilities should be there, emergency facilities should be there, and only the diagnosis can be done, and no procedures and no operations are done in diagnostic camps. The learned, I will say qualified, the ophthalmologist should do the examination of the patient and not the optometrist or the ophthalmic assistant.
Okay.
Sir, I have a question. If for some complication I need to change the IOL, like this one type of IOL was planned, and due to complication that type of IOL is not possible to be implanted, I need to change the IOL. Do I need
think
to
in the
take
informed
consent
consent,
for that?
sorry, please continue.
Yes, sir. My question is, do I need to change do I need to take the consent intraoperatively, or how should we manage it legally so that it is legally okay?
I think in the informed consents booklet, which AIS has formed, and we have translated that in Marathi language, and other states are also translating those consent books in their own languages like Telugu, Malayalam, Hindi, everything. I think that particular para is also written. So proper IOL for that procedure, if needed, that particular change can be done. And if in informed consent, the patient and relatives, they have signed that, probably they have been explained beforehand about that particular step.
Thank you, sir.
I have another question to the panelists. Actually, Dr. Nagpal's talk had a few case scenarios where bevacizumab was highlighted. So, what are the views of panelists since we are using bevacizumab on day-to-day basis? So, are we supposed to use it, or should we take a separate consent for that? How do we go about it?
I think that particular medicine, which was not supposed to be used for ophthalmology, because when that complication occurred, probably there was the issue all over the country because it was the cheaper option available in India, and the proper drug to be used only for ophthalmic use was very costly. So if it is not for ophthalmic purpose, why ophthalmology should use that particular medicine when there is so much of risk? But after so much of follow-up from various organizations like All India Ophthalmological Society, we could take particular sanction about that particular drug. Yes, because it is cheaper, and in Indian scenario, you can use that, because other option which is available is very costly. But then you have to be careful. Suppose there are no complications, nothing will happen. But if there are complications, probably you will be asked all those questions. Anything to be added by Mathur sir or Deshpande sir?
To add this, I have gone to that case when the case was actually lodged, and what was the problem was there when this case was there. The manufacturers, engineers, and experts were called, and their opinion was taken, and they given the opinion that this drug is off-label drug, and this is not for giving in the vitreous and the eye cavity. First thing. The another thing is that this drug is not having the preservative. So even a single bacteria goes inside, it can proliferate like anything in very fast. And if the second dose is puncture is being done, the bacteria can be implanted in the second eye. And like that, this drug should not be used. If at all it is to be used, it should be one shot only, and the remaining drug should be thrown away, and then should not be second prick. But this was the opinion given by those people, and it was correct because it was not having any preservatives. Other drugs, they are having preservatives, so those can be used, multiple pricks. Yes.
All right,
Anything?
sir. Thank you, sir. Dr. Aarti, are there any questions on YouTube? Can you see them?
No.
Okay. Dr. Kaushik, sir, any other members or on the chat?
I think we are already over time, but one thing is that the ROSE or the the producers of Avastin, they already have a conflict of interest in this, because they will lose business if they promote Avastin, because they are the they are the people who actually manufacture Lucentis, which is approved for the for this intravitreal injection, and the drug approval requires the manufacturer to apply to the authority that this indication be added, and they do not want to add that because that will lead to their financial loss. So this is another aspect which is essential to understand this topic.
So, sir, in current scenario, if we are using bevacizumab and if complication occurs, because I have heard that people are using it for ROP as well, like in higher centers as well. So if the complication occurs, it is definitely going to land you in trouble. Is that so?
Yeah. Because there is a court decision, and because the court decision says that it should not be used in eye, so it should not be used in the eyes.
Very
And
simple,
really
sir.
speaking, off-label drugs should not be used in the particular place where they are off-label.
You can use it until you get into trouble. That is what it is.
Yeah.
It's actually it's very correct. They will never add it in the indications for ophthalmic because they're promoting their other drug. They will never add it. But we know as practitioners, we know that it is very in a lot of indications. It's very advantageous to use it. But if you get into trouble, then there is no court or no judgment which can help you because
That's
it's
correct.
very clear there.
Correct. And they have given the statement like this in the High Court.
High Court, yes.
Yeah, because I conducted that case and I know the details.
Yes, sir.
All right. So if we do not have any questions, can we conclude the session, sir? Kaushik, sir?
I think it was a fantastic discussion, and all of us panelists, we really enjoyed, and it was fruitful discussion. Probably it was helpful to all ophthalmologists, youngsters, as well as seniors, those who have attended. And we're really enjoying this particular series of medico-legal aspects and various topics to be covered in the past, today, and in future also. We like to be connected with your YOSI sessions of medico-legal aspects. Congratulations to YOSI team on our behalf. Thank you so much.
Thank you.
Thank you. Dr. Bhatia has said I support it. And say thank you to all.
Thanks from me too for inviting me to the YOSI team, and it was a learning experience for me.
So yes, sir, we are really honored to have you all as our panelists, and we had a lot of good points we had discussed, and it is good for us also to learn these points in the initial stages of our practices.
Further, I suggest that Dr. Mathur should be our permanent panelist.
Okay, sir, we will go by your recommendation, and thank you so much for motivating us, for being with us. We are also taking baby steps when it comes to medical legal aspects in ophthalmology, and we are also feeling very confident. Kaushik sir will agree to me that it took us long time to start this series, but yes, we are also learning a lot, and I'm sure we are going to continue this journey with all of you.
Just to add one thing, at All India Ophthalmological Society platforms and at various state conferences, three of us are always together, Dr. Deshpande sir, Dr. Mathur, and myself. And this is the great opportunity to be associated with them, even on this platform. We really enjoyed this.
So we have found a very good trio for our session.
Yeah, thank you very much. Thank you. Thank you very much.
On behalf of YOSI Legal Core Team and YOSI Governing Council, I would like to thank all the panelists and speakers and Dr. Aarti and Dr. Kaushik and other members of my co-legal team for taking out time for this webinar. We'll be joining soon next for the next session. That will be third Friday of the next month. That is on record keeping, and we'll keep you posted and updated regarding the same. Thank you all. Thank you once again.
Thank you. Thank you so
will
much.
be on
Thank you.
20th of October,
Thank you.
most likely. Okay. Thank
Thank
you.
you.
everyone.
As of now, we do not have a WhatsApp group for this thing, but we are communicating in all the major channels, including YOSI groups and AIOS groups for about this webinar. And this is open for all ophthalmologists, not only YOSIs.
I have put it in so many groups flag, and I think so many people of DOS, including DOS and every lot many groups are informed, because lot many ophthalmologists are on my road.
Thank you so much, sir.
Thank you. Thank you.
Good night.
Thank you.
Okay.
Thank you,
Good night.
everyone.